With the permission of the magistrate, my learned friend I, Soleh Batisada, appearing for the defendant in today's case. My lord, today we are here today to tender our objections on the allegation made against the accused. We would like to start our submission today with the fact of this case. In this case, the accused Amran Fana with IC number 920113105095 was charged with the offence of consuming dangerous drug amphetamine on 5th June 2021 at about 4:05 p.m. at the Emergency Department of Jitra Hospital under Section 15, Subsection 1A of the Dangerous Drug Act 1952. We believe that the prosecution failed to produce a prima facie case against our client Amran Fana, and such contention is based on several grounds which are non-compliance by the authorities with the urine test guideline provided in the Inspector General Standing Order F103 and the Kementerian Kesihatan Malaysia Guidelines, also Section 31A of the Dangerous Drug Act 1952. Secondly, doubt as to the chain of the evidence of handling the urine sample, and lastly, doubt raised as to the drug result found at the end of urine test prepared by the pathologist SP3 on 10 June 2021. Before we present our arguments under the law involved for each of the issues that we mentioned just now, it is important for us to understand the meaning of burden of proof and the onus of proof before deciding any case in court. Originally, the burden of proof fell on the prosecution. However, it can shift to the accused. We refer to Section 101. The burden of proof is the burden of establishing a case, and this refers throughout the trial to any party confirming this issue, whereas the onus of proof refers to responsibility of proof, which is related to the responsibility of adding evidence to release the burden of proof. Next, referring to Section 102 of Evidence Act 1950 states that the burden of proof to show such evidence in any suit or proceeding lies on the person who is most likely to face failure in the absence of any evidence given by any party. In particular, levels of evidence in crime cases is beyond reasonable doubt. We refer to judgment by Denning J in the case of Miller against Pension, Minister of Pension. The level of proof should reach a level of the highest possible. As to relate to our case, the prosecution must produce a prima facie case, which is beyond reasonable doubt, which we believe, referring to the summary of evidence, the prosecution has failed to do so. With the permission of the magistrate, we would like to submit our argument as to why we believe the prosecution failed to produce a prima facie case against the defendants. Firstly, the non-compliance by the authorities with the urine test guidelines stated in the IGSO F103 and KKM guidelines, and also Section 31A of the Dangerous Drug Act, which we will refer to explain this issue. Referring to the summary of evidence, we believe that this court should carefully examine the conduct of the SPY in obtaining the urine sample from the accused. We find that the most material part of the Inspector General Standing Order F103 can be seen from its introduction, and the introduction shall be read together until the 8th part of the order, which we can summarize that the procedure stated the IGSO F103, the suspected drug accused shall be given 2 clean and empty plastic bottles in order to collect him or her urine sample. In addition, the suspected drug accused shall be given the freedom to choose the bottles. Besides, to summarize the Kementerian Kesihatan Malaysia guidelines, it can be understood that the urine sample shall be collected for 30 ml in one bottle or duplicate if the screening and the confirmation process are done in 2 different locations. Based on these 2 material positions of the authority, we can say that based on the summary of evidence, it shows that this SP2 failed to comply with the procedure stipulated in the IGSO F103, and since he did not give 2 empty and clean bottles to the accused for him to provide the police officer with his urine sample, instead the accused was only given 1 bottle. This contention can be referred to number 2 of the second column of the summary of evidence. We believe the next question that may be arised by the prosecution is whether the IGSO and KKM guidelines have force in law. For this matter, we would like to call for the court to refer to No Shariful Rizal case, where in this case it was held that both authorities have the force of law. The origin of the statutory power gained by the IGSO can be seen to Section 97 of the Police Act 1967. Therefore, it shall be adhered by the police, in which, in this case, the prosecution failed to prove such obedience had been done by the police officer, and this contention will refer to the summary of evidence provided to us. Referring to the case of Nur Shariful Rizal bin Nur Zawawi case, the appellant in this case had been said to have been deprived of the procedural law and his rights. It's only 1 bottle was given to the appellant, making the appellant urine sample was insufficient, thus contrary to the IGSOF 103 and KKM guideline. The appellant accordingly did not have a fair trial, and Articles 5.1 and Article 8.1 of the Federal Constitution were violated. The case has proved that the accused Amran Fana always has the right to personal freedom and fair trial. Procedural compliance is also part of the right of the personal liberty and equal trial. We would like to emphasize that it is the deprivation of right of the defendant Amran Fana, since the process of acquiring the urine sample for him is not done according to the procedures stipulated in the IGSO, KKM, and also the Section 31A of the Dangerous Drug Act 1952. The accused shall be examined by referring to 31A, a Dangerous Drug Act. The accused shall be examined by medical officer or any police not below the rate of subject in order to afford the evidence. But if you look back at the summary of evidence, this one the police officer that examined the accused was below the rank of sergeant, which can be said that the process stipulated in Section 31A of Dangerous Drug Act is not complied by the police officer. Hence, by referring to the case of Nur Ismail Abu Bakar, if urine test is not conducted in accordance with Section 31A of Dangerous Drug Act 1952, the presumption in Section 37K does not apply. The second issue is on doubt as to the chain of evidence of handling the urine sample. We would like to tender a contention there was a loophole in the prosecution case where urine sample taken on 5th June 2021 was only sent for analysis to the pathologist on 10 June 2021. There was also a gap of time for taking the urine sample, which clearly inconsistent with Section 31A, the DA, where the urine sample shall be taken within the reasonable time, which means as soon as possible, prior to the time the individual is arrested. But in this case, the urine sample only be taken 3 hours and 55 minutes after his arrest. We believe that the gap of time shows that it is in compliance with the Section 31A DDA 1952, and the gap of this would cause contamination to the sample. Pursuant to the case Gunala Ramachandran, tempoh penting dalam rangkaian keterangan barang kes adalah dari masa ianya dirampas sehingga dia dianalisa oleh ahli kimia. Thus, we strongly insist that the chain of evidence from the day the urine sample was taken until the day it was received by the SP3, the pathologist, is broken. The break in the chain of evidence shall be understood by the court that there is a reasonable doubt in the prosecution case. Last but not least, doubt raised as to the result found at the end of the urine test prepared by the pathologist SP3 on 10 June 2021. We refer to the summary of evidence. 5th June 2021, our client was said to be found positive for methamphetamine. But according to the SP3, the sample urine had been examined on 10 June 2021, found the urine was positive for amphetamine. This is the utmost doubt that we can tender in our submission, which we expect the fact would give a huge impact and cause influence in the decision of the court, for the court to produce an utmost just decision for our client, Mr. Amran Fana. Pursuant to Suah Peng case, menjadi pertimbangan penting dalam menentukan rantaian keterangan barang kes itu bahawa dari mula ianya dirampas sehingga ianya diserahkan untuk dianalisa, barang kes dadah itu telah dikenal pasti dengan jelas. That obvious flaw in the process shall be fatal to the prosecution case. Based on all reasons that I've mentioned, we believe that the prosecution has failed to produce a prima facie case under 3 issues that we have mentioned and discussed. There was non-compliance by the authorities with the urine test guidelines provided in the IGSOF 103, KKM guidelines, and also Section 31A of the Dangerous Drug Act. There is a break in the chain of evidence of handling the urine sample, and there is an obvious doubt raised as to the drug result found at the end of the urine test prepared by the pathologist SP3 on 10 June 2021. Hence, after considering all the law and authorities that we have tendered in our submission, we would like to seek from the court to grant the accused Amran Fana an acquittal and produce a just decision that would not deprive any personal rights conferred on our client, since there is a reasonable doubt on the prosecution case that we believe the court shall deem such instances to be fatal to the prosecution case. And that's all from us, from me. Thank you.